Good afternoon, advisors. This afternoon session, as I've stated, is for high school mock trial advisors. If you are a middle school advisor, they are having a middle school session over in 102. The first thing we'll be going over today is the rule changes. A reminder that we are filming this session for advisors who could not attend in person to still receive this information. So at this time, we will not be taking questions on the rule changes. All these rule changes will be in the case file that you received today at 5:30 p.m. if you purchased the case file in advance. After your review of the case file, if you still have questions, please reach out to me. All right. So, as you or most of you know, we sent out an email at the beginning of the school year. I believe it was around August 20th. And we released rules regarding the forming of teams after feedback from advisors. So that's what I'll go over first, is the rules that we have already released. All right. OCLRE has worked with our sponsors, our county coordinators, and community partners to determine capacity for this program season. Schools will be permitted to register a maximum of 3 teams for the 25-26 mock trial competition. And please remember that schools fielding more than 1 team may be placed outside of their home county and/or at multiple sites. 2, team eligibility. Schools wishing to field 3 teams must have at least 1 team with 9 students. So that is a change in eligibility from last year. 3, protection against oneself. All teams will receive protection from playing their own school at the district level of competition. No such protection will apply at regionals or states. A new rule regarding maximum site composition. No single school will exceed 40% of a district competition site. As a result, schools fielding more than 1 team may be required to travel to alternative sites or split between 2 sites. All right, again, and those rules have been released in advance to help you form your teams at the beginning of the school year. Now we are going to go over rule changes that have not been released. We will be eliminating the play-in round at the competition, specifically at the state competition. So the way we will handle that is, if fewer than 8 teams win both trials, advancing teams will be selected from amongst the teams with a 1-run record as indicated below. First, the percentage of ballots won at all levels of competition will be calculated. The number of teams needed shall be taken from that poll in order of percentage of ballots won. If teams are tied for the percentage of ballots won, the average point total from across all levels of competition will be used to break the tie. If a tie still persists, the remaining vacancies will be drawn at random from among the tied teams. If more than 8 teams win both trials, the 8 quarterfinalist teams will be determined using the procedures below. All 2-0 teams will be ranked in order of percentage of ballots won across all levels of competition. The 8 quarterfinalists will be determined based on this ranking. In the event of a tie in percentage of ballots won, the average point total from across all levels of competition will be used to break the tie. The role of awards, there's been a rule change. This rule change affects many areas of the case file as we discuss awards at many points, so please review this. But just know that the change that has been made is awards will play no role in any tie-breaking or advancement of decisions at any level of competition. Again, review your case file when you get it today, and if you have any questions regarding that, let me know. The next few things are not necessarily rule changes, more clarifications. The first one is a clarification on the material rule violation. A material rule violation is 1, a violation of a competition rule that 2, affects the fairness of the trial. If the majority agrees that a competition rule was violated, but that it did not affect the fairness of the trial, it is not material, and therefore no deduction will be taken. One example of a material rule violation, which a panel may find to be material, is a witness using notes during examination or a team using 3 attorneys instead of the designated 2 attorneys. All right, again, these are more clarifications and not necessarily rule changes. Clarification on witnesses behind counsel table. In instances where one or more of the witnesses are a party to the case, they will sit with the other witnesses to be called in the case. The only students permitted at counsel table will be the students playing the role of counsel in the trial. Clarification on role of advisors. During the post-trial objection phase of the trial, attorneys may communicate with any rostered team member or advisor. Communication may not include the passing of notes, the scripting of objections, or other such prepared communication provided to any team member. And our last clarification here, all witnesses will remain in the courtroom, but are deemed to be constructively sequestered. Therefore, it should be assumed that witnesses are unaware of prior trial testimony and no motion for separation of witnesses shall be necessary. In a criminal case in which the defendant is a witness, the defendant has the right to be present for the entirety of the trial and is not subject to witness separation. All rules relating to student placement and seating within the courtroom still apply. All right, so that was a summary of our rule changes. Like I said, some of those you already knew about, especially the ones about forming teams. Some of those are about the state competition, like the plan round, but a lot of those were simply clarifications and not necessarily full-on rule changes.